Good afternoon, everyone. My name is Troy McKenzie. I am the Dean of NYU School of Law, and I would like to welcome you to this session discussing Dobbs against Jackson's Women's Health Organization. Thank you for taking the time to join us today. If you're present, you likely know about the case and the importance of the case. We are extremely privileged to have with us three experts with deep knowledge and experience in this area to talk about reproductive rights, the impact of the Dobbs case, and what the future might hold. I'm going to very briefly introduce our moderator and panelists, and then I will turn the discussion over to our moderator, who is Melissa Murray. Professor Murray is the Frederick and Grace Stokes Professor of Law here at NYU. She's also the faculty director of the Birnbaum Women's Leadership Network here at the law school. She is an expert on family law, reproductive rights and justice, and constitutional law, and has researched and written broadly in those fields, and specifically has researched and written about the regulation of intimate life and sex and sexuality by the law. She is a true thought leader, appearing in the Harvard Law Review, the New York Times, and she is also the author of Cases on Reproductive Rights and Justice, which is the first true case book to cover this field. We're also joined today by panelists TJ Tu and Whitney White, both proud alums of this law school. TJ is a 2003 alumnus. He is general counsel for the Center for Reproductive Rights, and he is also an adjunct professor here at the law school, where he leads the Sexuality, Gender, and Law seminar. He began at the center in 2018 and is a senior member of its US litigation team. And in that role, he has worked as a pivotal member of the litigation team, including being co-counsel in the 2020 Supreme Court case, June Medical Services against Russo, in which the Supreme Court, as it was then constituted, in a 5-4 ruling, struck down a Louisiana law requiring doctors performing abortions to have admitting privileges at a local hospital. Whitney is a 2018 alum of the law school. She is a staff attorney with the Reproductive Freedom Project at the ACLU. In her work with the Reproductive Freedom Project, she engages in litigation and advocacy to protect and expand access to comprehensive reproductive health care, including abortion, and to fight against federal and state laws that deny individuals the ability to control their reproductive health and lives. She is currently lead counsel in a state court challenge to Florida's recent 15-week abortion ban. So I want to thank Whitney, TJ, and also Melissa for kicking off this discussion. And I will now turn things over to Professor Murray to get us started.
Thanks so much for that, Troy. It's great to be here virtually with everyone in the NYU community to discuss this issue, which has really reshaped the landscape of constitutional law in just a few short weeks. I do want to acknowledge that we have a number of recent graduates who are at this minute sitting for the bar exam. We wish them the best of luck in that endeavor. And we also have a number of rising 2L students who are in the middle of early interview week. So they're not able to participate at this moment in this program, but we will be taping this so that they can later learn from these alumni experts. And we are incredibly grateful to both TJ and Whitney, who are literally mired in legal work right now around this issue, but have taken the time to join us to discuss these questions. So thank you so much for continuing to make NYU law a priority in your professional lives. And so just to get us started, and in order to perhaps do some level setting for our audience, can you, TJ, help us understand the majority decision and exactly what did the majority decision do?
Sure. Let me just start by extending my thanks for having me here as the dean said, I am a proud alumni. NYU is really important to me and continues to be. So very glad to be here, even though the topic is one that's very distressing to me and to my organization. The Dobbs case was the center's case. We represented the last clinic in the state and challenged this 15-week abortion ban. And when the Supreme Court took it, the question that was before it was whether this 15-week ban on abortion could stand under Roe v. Wade. And the court said, we're going to skip that question and go to the heart of the matter and revisit Roe entirely. And Justice Alito, on behalf of a majority of the court, said, yeah, I'm looking at the Constitution and I just don't see a right to abortion there at all, despite the fact that the Supreme Court for 50 years had said, in fact, the right to be able to choose whether to continue a pregnancy is a fundamental right. And the court had numerous times, including in Casey, reaffirmed that right. The majority used an analysis to get there that is troubling both for abortion rights advocates, but for lots of other areas of law, by taking an extremely narrow view of the rights that the Constitution protects and an extremely narrow view of how judges are meant to answer the question of whether the Constitution protects certain rights. And I'm happy to unpack that further, but in a nutshell, the court said, unless this right is firmly rooted in the nation's history and tradition, it's just not going to be protected by the Constitution. And when we talk about the history and tradition of the nation, we're talking about very narrow periods of our history, in this case, in the 19th century, to say that at the particular time that the 14th Amendment was enacted, what was the state of play when it came to abortion rights? And unless there was a positive recognition of abortion rights, well, then the Constitution never should have acknowledged that women and pregnant people have this right at all.
Okay, so just to sort of like make that more clear for the audience, like there are basically three parts of this opinion. The first part upholds the Mississippi 15-week ban. The second part goes further to overrule Roe versus Wade and Casey. And then the third part establishes a standard of review for all abortion restrictions going forward. And it sets that standard of review at rational basis review, which is the lowest level of judicial scrutiny. Whitney, I wanted to back up to something that TJ said initially. And he noted that when Mississippi filed its petition for certiorari before the court, its ask of the court was relatively modest. It was simply seeking an answer as to whether a state could permissibly enact a 15-week ban or whether that 15-week ban violated Roe and Casey. It was only after the court granted certiorari, and indeed only in 2021, when Mississippi filed its first brief before the court, that it made this much more cataclysmic ask, asking for the court to review and overrule Roe versus Wade. Can you help us understand the sort of political landscape that led Mississippi to go from what was a modest litigation posture to something more aggressive in such a short period of time?
Sure. So first, I just also want to say thanks so much for having me. I'm so glad to be with the NYU community discussing such an important moment in the history of the courts and for the country overall. So exactly as you said, the initial ask, I think, in Mississippi's first brief asking the court to accept cert, there was only one footnote that referred to the possibility of overruling Roe versus Wade. But in the interim, between when they filed that cert petition and when the case was accepted for review and they filed their opening brief, the composition of the court had changed drastically. I think it's important to recognize that there has been a very long history, far predating this opinion, of states and anti-abortion advocates and politicians trying to roll back the protections that Roe and Casey granted to abortion rights from very, very early on. And that has been resulted in a real sort of onslaught of laws that at the time that they were passed were blatantly unconstitutional. And it's been part of a intentional strategy to try to continue to push the boundaries of the constitutional doctrine further and further to the extreme, and to try to figure out and prompt ways for the court to reconsider the protection for the right to abortion. And that's precisely what ended up happening here. But I think it's important to recognize that this didn't come out of nowhere. It's been a very long-standing strategy to try to continue to sort of move the window of what's appropriate and constitutionally permissible for abortion restrictions. Now we've ended up in a place where the entire right to, the entire federal constitutional right to abortion has been eliminated. But I think it's also important to keep in mind that this is not going to be the end. There's nothing to suggest that that the people and the politicians that are dedicated to giving the state a really pervasive interest and ability to regulate individual bodies, individual choices about their medical care, that there's any reason to believe that they'll stop here and they won't continue to push, not just to send things back to the states, but potentially to even get a nationwide ban to abortion. So I think that this is part of a long narrative, and it's certainly not the end of that narrative either.
Okay, TJ, can I go back to something that Whitney said briefly? So this is a long-standing conflict. This is something the majority noted in the opinion in Dobbs, that Roe and Casey inflamed national controversy over abortion rights. Casey purported to settle it, but actually exacerbated that controversy. As Whitney suggests, there have been efforts to roll back reproductive rights, suggesting that this has really been a very divisive issue in American politics and American law for some time. And one of the things the majority opinion purports to do is to settle that controversy by simply restoring this question to the states rather than to a federal court to resolve. Can you talk a little bit about this question, of this idea of judicial neutrality that is at once raised by the majority and also by Justice Kavanaugh in his concurring opinion, and sort of the question of returning this to the states for democratic deliberation?
Sure. I mean, there's a lot going on in that question, but this notion that the court's decision settled the matter, does it feel settled to you? From where I'm sitting, it feels like the country has ruptured, and it's not going to change anytime soon, but rather the battle lines have been redrawn. The matter is contentious because the subject matter itself is one where people have deeply held personal, religious, moral views. It's also highly contentious because those views have been politicized in ways that give political actors advantages to take certain positions that advance their own political agenda and objectives. Nothing about the court's decision changes those fundamentals that lead this to be a contentious issue in our society. And in fact, if you look back at Roe and Casey, it wasn't like those courts that decided those cases had some naive understanding that this was no longer going to be contentious and that we can just wipe our hands of this and everyone will go about their business. The judges who wrestled with those cases understood this is a contentious matter, and they said, look, in a society such as ours that is pluralistic, where people have this divergence of views, what is the grand compromise that's going to say everyone's going to come at this with their views, but what can we agree as a constitutional matter are the fundamentals? And the fundamentals are that states can differ in how they regulate abortion, but fundamentally they can't deprive a pregnant person of the right to choose whether to remain pregnant prior to viability. That was the central compromise position of Roe and Casey. And even though that was the compromise, controversy continued to swirl. Now they've taken that out and said, no, the battle line is way back there, meaning states, in fact, can regulate this to the point where people can be deprived of that fundamental choice, and your Constitution has virtually nothing to say about it. But the fundamental difference, the intractability, will remain. And so we should all fasten our seatbelts, because regardless of how you come to this conversation and your own views, we are going to be living with this controversy and the aftermath of the decision for our entire lives.
And some would say we've been living with it for a long time. Like, the specter of abortion has shaped our politics, and in particular judicial politics, in a really profound way. The confirmation of Supreme Court justices has been conducted almost entirely in the shadow of Roe and the possibility that Roe would be overruled. It has shaped the decisions of sitting justices about when and whether they will retire. Justice Ginsburg famously stayed on the court because she feared that the president would not be able to appoint someone who would be as progressive as she was on questions of abortion rights. And again, it's worth noting that one of the things that intervened in the period between when Mississippi filed its petition for certiorari and when it filed its first brief asking the court to overrule Roe versus Wade is that the composition of the court changed with Justice Ginsburg's passing and the installation of Amy Coney Barrett in her stead. So again, this has been a very divisive issue. But Whitney, is the court correct? Is the majority correct that we can compromise on this if we simply return it to the states? And then we will have red states who want to prohibit abortion because that's what the majority in those jurisdictions favor. And then there will be blue states like New York and California whose populations will require and indeed just want more expansive abortion rights, and they will have that. So is this the grand compromise that Roe and Casey tried to strike, and it's simply as easy as returning this to the states?
I don't think so. I think it's important to keep in mind what it means to send this question back to the states first and foremost. And so I want to draw a contrast between, I think both the majority and Justice Kavanaugh and his concurrence kind of equate returning the question to the states with returning it to the people. But I think the important contrast is that under Roe and Casey, individual pregnant people got to make the decision about whether to carry a pregnancy to term or to have an abortion. Under this decision, that choice can now rest in the hands of the government and be subjected to a majority vote. So I think there's first just sort of it's important to kind of keep in mind the degree to which this is not about sending power back to the people. It's about sending power to the states and giving the state control over deeply personal and intimate decisions that we make about our own bodies, about our own health, about our own lives. Secondly, I just think it's just wrong that all this decision does is send things back to the states. Without federal constitutional protection for the right to abortion, the door is open to a federal ban. And anti-abortion politicians are already calling for one. Justice Kavanaugh's concurrence itself acknowledges this as a possibility in referring to, when describing the Constitution as neutral and saying that all we're doing is leaving this issue to the people. The concurrence actually says, through their elected representatives to resolve through the democratic process in the states or Congress. So the notion that this is going to stay with the states and that there isn't going to be a concerted effort to decide the question once and for all by banning abortion nationwide, I think is just ignoring the reality. And in fact, Justice Kavanaugh at least is relatively upfront about acknowledging that. I think there's also a lot of reason to be skeptical about the degree to which this is just going to rest with the states for two reasons. One being that we're already seeing states that have banned abortion exploring or trying to figure out ways to extend the reach of their abortion bans beyond their own borders. So trying to figure out ways to criminalize their residents seeking and obtaining abortion care out of state, even in places where that care may be legal. So, I don't think there's going to be a situation where there are just these, clear boundaries. Missouri tried to, or introduced and didn't actually pass, but introduced a law that would have tried to criminalize out-of-state abortions for its own residents last year. I think that's a model that we may see other states trying to do. And to put in place other tactics to prevent their residents from being able to access care where it remains legal. And also, laws like Texas's SB 8 and the Oklahoma copycat that provide civil actions against not only providers providing abortion care, but friends or family that help people provide assistance to accessing care. That's another mechanism and another legal model that already exists that could have the effect of deterring the ability for people to access care out of state and for really penalizing them for being able to do so. I think the last thing that's really important here is just the notion that this is just going to be worked out through the democratic process. There's a lot of reasons to be skeptical of that. The same justices in the majority in Dobbs, have been part of a series of decisions systematically dismantling voting rights protections and allowing states to engage in partisan gerrymandering or other voter suppression tactics. So it's not just that abortion rights are being rolled back. We have this decision saying, let's just leave it to the ballot box. But I think there's a lot of reason to be quite concerned about whether or not people are going to have effective access to the ballot box and be able to have their voices heard by their elected representatives. I want to say that that doesn't mean that voting is not important. It still is, but I do think it's important to look at the bigger picture and how this rollback of abortion rights is fitting into a wider landscape where a lot of our rights are under attack, including the right to vote.
Well, which is it a really important point, and too often when we think about reproductive rights, we think about them as siloed from these other issues, including the right to vote, but in fact, they are inextricably linked. Can I go back to something you just said, though, Whitney? You mentioned this question of mobility between states and the prospect of a state like Missouri passing a law that prevents individuals within its boundaries from leaving the state to seek abortion care in more hospitable jurisdictions. And you also noted the prospect of copycat laws, like copycat SB 8 laws that penalize private citizens for furnishing assistance to those seeking abortion care. Aren't there other constitutional provisions that perhaps would be limits on a state's ability to do so? So I'm thinking specifically of the right to travel as a limit on a state's ability to prevent the mobility of its residents, and perhaps even a First Amendment challenge to a law that would prevent someone from furnishing assistance, especially if it was in the form of financial assistance or a donation to an organization like an abortion fund that would provide assistance to pregnant people. Are those possible avenues of contestation?
Yeah, I mean, I think there's definitely, I think we're at a place now in the wake of the Dobbs decision where it's really important to keep all legal tools and strategies, on the table. We definitely need to be thinking about other theories that can protect people in accessing care. And I think the right to travel and the First Amendment are both very important parts of that. But I think, where we are right now is a situation of profound legal uncertainty about how these different doctrines are going to interact with each other. And so there is already a lot of harm being done by the very fact of that uncertainty. We know that states are going to keep trying to anti-abortion states are going to keep trying to push the boundaries here to make it more difficult for people to get out of state to seek the care that they need. And in the interim, you're going to have a situation where patients and providers, because of those attempts and because of the profound legal uncertainty, are going to have a lot of confusion and doubt about what conduct actually is constitutionally protected. And again, we're talking about an environment where these abortion bans, most of them are criminal bans with very severe penalties. And so I think there's a situation where the effect of this legal uncertainty and how destabilized these questions have been about what kind of conduct is legal and in what circumstances you can seek abortion care is going to result in a situation where people are chilled from exercising their constitutional rights, even if there might be these other doctrines that would protect them. Patients will be chilled from seeking care because they don't know whether they can or how to get care out of state, or they're deterred from seeking the support of friends and family or medical providers out of fear of getting into trouble. And providers are going to be in a situation where they have serious doubts about how they're able to treat patients from other states, and not just limited to abortion, but we're already hearing reports of providers being in real states of confusion about what kind of care they can provide to patients undergoing pregnancy complications and miscarriage management. So I think, while there definitely may be a lot of other legal doctrines that could help in sort of preserving certain access, including to interstate travel, and we want to sort of keep all of those options open and push those where we can. It's also the case that just the fact of the legal uncertainty is going to have a real impact on the ability of people to exercise their rights.
And this, oh, sorry, TJ, go ahead.
And this is by design. I mean, listening to Whitney talk, I'm reminded of the whole debacle of SB 8 that was occurring at the same time the Supreme Court was considering the Dobbs decision. I'm sure many people in attendance know that story, but it's important to remember that Texas passed a 6-week ban on abortion that was enforceable by private vigilante citizens with a bounty of $10,000 per unlawful procedure. And what's notable about that is that very few lawsuits were ever filed under SB 8, but it was the mere threat that such lawsuits could be filed and could impose crippling liability on people who not only provided the care, but assisted, who were the receptionist at the clinic or the Uber driver. Rational actors responded to the law by saying, you know what, the safest thing to do is not provide what at the time was constitutionally protected care. So you can see how a legal regime can have its effect without it actually being operationalized in any meaningful way. And now we're living through a similar circumstance, but it's gasoline on the fire. You now have these legal regimes in all of these states that are hostile to the right of abortion kicking into gear, criminal penalties, conspiracy liabilities, all these different things causing people to say, you know what, the safest thing for me to do for me, my family, the people that I care about is just to get away from the issue of abortion, certainly get away from the provision or assistance of abortion care. And people need lawyers and exceptional bravery to get through the next very uncertain period of time.
So TJ, I'm thinking about how I'm going to get through the next couple of years. And in particular, I'm thinking about how I'm going to teach constitutional law to first-year students in the spring. And I have for years taught Planned Parenthood versus Casey as a case not just about abortion, but about precedent and how we think about the circumstances under which we depart from precedent. So can you say a little bit about what the status of precedent on precedent is after overruling a precedent about precedent?
You know, I think it raises serious questions for all of us who care about what conceptually we think of as the rule of law. When I went to law school, concepts of the rule of law, they always seemed somewhat of an abstraction. We knew it was related to stare decisis, the notion that courts should adhere to prior decisions unless there's been some real seismic change in the world that suggests that a decision has really become outmoded and no longer fits the times. And we're now living through a period of tremendous uncertainty, because if the court can come in and say, not only we're going to relook at Roe and just toss it out completely, but we're going to look at Casey, which was a case where the court confronted the central question of, okay, we get it. This decision has some warts on it. A lot of people don't like it. But we as an institution, as the people who are responsible for overseeing the rule of law and the administration of justice, we're going to hold hands and stick to this rule because in the long run, it's necessary to do that for the credibility of the court. This Supreme Court in Dobbs looked at Casey and that logic and threw that out as well. So if that is no longer the guiding principle of how we think about the rule of law and stare decisis, I'm not sure what the guideposts
Well, can I
are.
push back a little? So in his 2019 concurrence in Gamble versus United States, Justice Thomas said that it actually was worse for the credibility of the court to continually reaffirm an opinion that in his view was egregiously wrong. And so is there a world in which departing from precedent doesn't hobble the court as an institution, but rather enhances it?
There could be those scenarios, but this isn't one of those. I mean, the dissent in Dobbs points out directly that the biggest problem for the court is the perception that just the change in the makeup of the justices changes the rule of law. That fundamentally causes the public to view the court as political actors. And here, it's almost like a controlled experiment. If you just step back and look at the three most recent abortion rights cases that the court took. In 2016, the court took a case involving an admitting privileges law coming out of Texas. This was a law that said that abortion providers have to have admitting privileges. It was a catch-22 because abortion providers, for lots of reasons, can't get them. The court looked at that and ruled that law is unconstitutional. Roe is reaffirmed, and this law has to fail. One justice of the Supreme Court changed, and they took up the identical case coming out of Louisiana. That was a case that I was involved in. And our central argument was, look, for the good of the court, it has to be the case that if you are looking at an identical law 2 years later, and the only thing that's changed is the makeup of the court, public confidence in the court and the court's legitimacy will be called into question if you reach a different result. And by 5-4, we squeaked by with a victory in that case where the court said, yes, again, reaffirming Roe, reaffirming Casey and striking down that law. And then just one more justice changes and the whole thing falls apart. And the question is, what could possibly justify a rational court system to say that the rule of Roe was still good law and the right to abortion was fundamental in 2016, it was fundamental in 2020, and today it doesn't exist? I can't see how that could possibly reflect well on our system of justice.
So essentially you're saying it's not about principle and precedent, it's about personnel and politics.
Certainly the dissent in Dobbs thinks that's the view. And one question is whether our standards of stare decisis are too malleable that it permits this. Because of course the court says that it's applying the rules that you apply when you revisit precedent and determine that it should be overruled. And yet, despite adhering to all of these facial principles that guide a court's analysis, they managed to undo 50 years of precedent in one fell swoop.
Did
I
you
just
wanna
want to
say
pick up
something?
on that last point. Yeah. So I think the other thing that really sets this decision apart from other instances where the court has overruled itself is that this decision really stands alone in terms of unrecognizing a fundamental individual constitutional right in this sort of profound and very stark way. Like, this is a right that people have relied on for nearly 50 years in this country. And so I think also just the nature of what's happening here, the court going from saying, each individual person, here's a fundamental right that you have to yourself that's good against the government, and now saying, actually, the government can make these profound personal choices for you. I think that also sets this decision apart in a way that, I don't think we've seen the court do something like this before. And I want to just key in a little bit within the stare decisis analysis on the way the court talks about reliance. I think one of the things that is notable about the stare decisis analysis here is that the court, to me at least, is actually making some subtle changes to what the stare decisis test is in purporting to apply this really well settled rule about how we consider whether or not to overturn precedents. And one of those is that the court, one of the sort of 5 factors it applies is around reliance interests. Now, Casey also talked about reliance interests and recognized, the ways in which the right to abortion has been really central to how people organize their lives, how they structure their intimate relationships, plan for their futures, and do that around the notion that abortion is going to be available and that they're going to be able to control their own fertility and control the timing of when and if they want to grow their families while they make all of these other plans, career plans, education plans for their futures. And the court in Dobbs here said, no, that's not the reliance we're talking about. So even though there is this real sort of undeniable evidence about how important this decision has been to society into allowing people to build the families that they want and to build the lives that they want, the court has really shrunken back and said, that's not the kind of thing that we look at. All we're really looking back at here is concrete reliance interest, things like property and contract rights. So no matter how profoundly this decision and the right to abortion and being denied an abortion, no matter how profoundly that can affect individuals, the court is basically saying that's no longer part of the legal test.
So let me, in keeping with this theme of stare decisis, we have relied on stare decisis not only for predictability and understanding what the scope and substance of our rights are, but whether we even have these rights to begin with. A number of people have argued that this decision opens the door for not only withdrawing abortion rights, but perhaps even reconsidering and withdrawing other rights, what my colleague Peggy Cooper Davis has called the rights of heart and home, like the right to use contraception or the right to marriage, the right to same-sex marriage. Are those on the table, TJ, now that the court has opened the door here? Because the majority says quite self-consciously that this decision does not implicate any other prospective rights. It is only about abortion because abortion is the only right that implicates the prospect of potential life.
Certainly that's what they say. And the dissent points out that they just simply can't be believed when they say that, because the rationale that the court uses to get rid of Roe and to get rid of Casey is extreme. It's extreme in its narrowness of what the Constitution actually protects. And if you take them seriously, then these other constellation of rights that the court has recognized, all these rights involving house and home, including, the right for me to marry my husband, is very much on the line. Because if you think about, well, if our guide star here is history and tradition of the United States at a very specific point in time, and nothing else matters, and to Whitney's point, that it's no longer permissible for the court to consider the effects of the decision on the lived experiences of people right now, then it must lead you to the conclusion that a right, for example, to marry a same-sex partner, the right to contraception, the right to interracial marriage, they can't comport with the court's analysis. And certainly now you're seeing in Congress a reaction to this, where legislators are seeing that other rights are very much on the chopping block, and they're moving very quickly to propose legislation that would protect these rights and shore them up as a statutory matter.
And so this is just a question of the logic of the opinion cannot be confined to abortion. If abortion is a constitutional apostasy because it's not explicitly enumerated and it's not rooted in our history and tradition, you could say the same thing of these other rights. Justice Thomas, in his concurrence, Whitney, notes that the majority has very much tried to sequester the question of abortion from these other rights. And while he agrees that this decision is about abortion, he concurs separately to make clear that he would welcome and indeed would invite a series of other challenges to other quote unquote substantive due process precedents like Griswold versus Connecticut, which secures the right to contraception, and Obergefell versus Hodges, which secures the right to same-sex marriage. And he argues that these two are egregiously wrong and unmoored from constitutional text and should be overruled, although he does leave open the possibility that perhaps there are other constitutional provisions that might support these rights. It's just it cannot be lodged under this rubric of substantive due process. Is this the way forward? Are we going to see real challenges to things like same-sex marriage, the right to contraception? Is this the future for us?
I think that as TJ said, based on the methodology that this opinion uses, there's no reason to suspect that those rights aren't also in danger. I think the stare decisis analysis makes clear that the most important consideration, the first consideration, is whether the constitutional question is decided correctly. And according to the Dobbs opinion, whether the constitutional question is decided correctly turns on this originalist, historically rooted methodology that it really breaks from constitutional traditions that the Supreme Court has used in the past to decide whether constitutional rights are supported in sort of the narrowness and sort of how extreme its sort of commitment to this sort of textual originalist notion is. And what the majority opinion says is that the only rights supported by the Liberty Clause in the 14th Amendment are those that are either explicitly named in the first 8 amendments or those that are deeply rooted in history and tradition. And when considering that second question, the majority engages in this historical analysis that sweeps to the side all of the historical evidence that there is that abortion was widely deemed to be permissible, widely permitted under the common law, at least up until the point of quickening, which is the point at which the pregnant person can feel fetal movement, and generally doesn't happen until between 16 and 20 weeks of pregnancy. The majority sweeps all that aside and really just keys in on sort of a narrow set of historical documents, looking at state constitutions or state statutes that, of course, were passed at a time where the entire government was in the hands of a few, and the majority of the population was disenfranchised and not recognized as equal persons or as equal under the law. And so I think there's a real problem with a situation in which if this is the way constitutional interpretation is done, and the fact that a particular population or a particular right has been denied, and that denial has been government sanctioned in the past, if that's a reason to continue denying rights now, then that's really, potentially devastating for other individual rights and liberties, especially for populations that, if you look at the history of this country, have had to continually fight and struggle for recognition of their equal humanity and their legal rights in the face of legally sanctioned discrimination. So I think there's a real reason, definitely to be concerned about the rights that Justice Thomas named, but really any right that isn't explicitly in the text of the Constitution, I think is up for grabs.
And it's not as if the justices are being coy about the project that they're undertaking. They're saying out loud where they want to drive the bus. And so we should take that seriously. Just again, I keep going back to the case of June Medical. There, the court 5-4 strikes down an abortion restriction and upholds Roe. But the dissenters found a way that they would have said, well, the law is fine, even keeping Roe intact. But Justice Thomas is like, oh no, I'm going to write for myself. And, this whole thing, this whole Roe v. Wade business, we should just toss that out. And now you flash forward just a couple of years, and a majority of the court is now embracing the position that really commanded only one justice at the time. And as the dissent points out, when it comes to Obergefell and the right to same-sex marriage, 2 justices have already taken a public position that they think that should be overturned.
So this is a kind of triumph of originalism. And, I think it's worth noting here that originalism really hews back to this idea that we should interpret the Constitution and its amendments at a time one, either the founding when the Constitution was ratified or at the time the amendments were ratified. In this case, that would be 1868 when the 14th Amendment was ratified. But the history that Justice Alito uses in this majority opinion is really selective and itinerant. And, I know I've mentioned Peggy Cooper Davis already, but I will do so again. She has this wonderful book, Neglected Stories, The Constitution and Family Values, where she notes that the 14th Amendment proceeds from this abolitionist ethic where they were trying to restore to these newly freed individuals the rights that marked freedom from slavery, among them control over your body, both for labor and in terms of sexual coercion, the right to control your family, to keep your children with you and to raise them without having them sold away from you. And so there is an originalist history that actually does support a notion of bodily autonomy that would in turn fuel a right to abortion. And it's utterly absent from this majority opinion, but it's also utterly absent in how we talk about this right. It may be the case that those who favor abortion rights have conceded too quickly that this is unmoored from constitutional text, that we've conceded that this is unenumerated when in fact it is part of the understanding of liberty at the time the Reconstruction Amendments were ratified. That's just me sort of riffing here on some great work that Peggy has done. We've gotten a number of really terrific questions from audience members, and I want to make sure we don't give them short shrift. And there are a couple of questions about this issue of religious liberty, and a number of audience members have noted that this is a court that seems especially interested in the prospect of a more robust understanding of free exercise. And so they are asking if it makes sense to pursue challenges to anti-choice laws on the ground that certain religions actually require the availability of abortion in order to preserve the life of the mother, the life of the pregnant person as part of their religious tenet. So can you speak a little bit about this, TJ?
Sure. To Whitney's point earlier, at the moment, we're keeping all of our potential weapons in the arsenal, and religious liberty claims are one of the things that we're looking at closely. A number of other groups have been laying this groundwork for several years. There's a group at Columbia, there's a number of practitioners in the religious liberty field that have been pursuing this. And I think we will see a proliferation of religious liberty cases. I think it's a challenge because, we in the seminar that I teach talk about how federal courts often kind of read the tea leaves when the Supreme Court comes in with a seismic decision, and that cases can have ripple effects beyond just their particular doctrinal bucket in which they sit. And so one of the challenges you have to think through is whether, in light of Dobbs, would the Supreme Court recognize an abortion right, even if it were brought up under some other constitutional doctrine. Certainly the majority gives a little bit of a tell here when they go out of their way to say, oh, by the way, if you're thinking of reframing these claims as equal protection claims, the Equal Protection Clause has nothing to say about the abortion right either, despite the fact that that issue was never raised, briefed, or argued to the court. So there's reason to proceed with caution. That said, I think the questioners are exactly right to think that there's something to this. And I know there's a lot of advocates who are going to invest here.
Whitney, did you want to add anything?
Yeah, I mean, I think, thanks. I think that also, to your point, Melissa, you said a few minutes ago about areas where sort of abortion rights advocates have maybe conceded things too quickly. I do think there's a lot of value in these claims and in sort of attempts to reclaim this space and reclaim the narrative. Because I think this is another place where for too long, there's been this prevailing notion that one narrow religious view, one that is rooted in Christianity and a particular conservative brand of Christianity, is synonymous with the religious view on abortion. And that's also just not the case. And so I think it's really important that a lot of these free exercise and religious liberty and establishment clause claims and approaches to this issue are doing a lot of work to reset that narrative and to acknowledge that there are a wide variety of religious beliefs on abortion, even within Christianity, but of course across other religious traditions as well, across Jewish, Hindu, and Muslim traditions as well, that provide very different circumstances on abortion. And not only, view abortion in certain circumstances as religiously permissible or tolerated, but as actually condoned and as actually, central and important to the exercise of religious values. So I do think that it's important, and there is a lot of important work to be done to bring back to the conversation about abortion rights just how diverse the views are, and there's certainly not only one religious view on the question. And I think that is something that there's been sort of a monopoly on that conversation from one side for a while, and so I really welcome opportunities to kind of reshape that narrative and give more diverse viewpoints a turn.
Well, that really speaks to the prospect of using the free exercise clause to make clear that there are, we live in a multi-faith democracy and there may be different faith communities that have different views on this. What about the prospect of using the establishment clause, like the idea that a state passing a ban on abortion, or state, for example, passing a law that says that life begins at conception, that is akin to essentially establishing a religion within the state because it espouses a particular religious view. Is that something that's worthwhile to think about or meritorious as a line of argument?
I think it's definitely worth exploring. I do think that most states and the majority, when it talks about the legitimate interest in protecting and preserving prenatal life, even though the view that life begins at conception or fertilization, can be aligned with particular religious viewpoints, I think the courts and state legislatures have been pretty careful to try to couch this in more neutral, moral objections or moral viewpoints. And now the majority even talks about it around this sort of like balancing of interests and saying that, we are going to be neutral on the question of at what point states should decide that legal rights can be accorded to prenatal life. And so, I do think that it's, as TJ said, we want to keep, as we've said multiple times, we want to keep all the tools out there and explore different and creative strategies to try to protect and preserve access, wherever possible. But, at the same time, I think there are sort of routes that the majority kind of makes clear in recognizing this sort of legitimate interest and not sort of pinning it to a particular religious viewpoint, but it's something that is, presumptively legitimate as a state interest.
So here's another audience question, and I think it's a really interesting and provocative one. Even before this decision, there were those who argued that we should be encouraging individuals to take care and responsibility in the conduct of their sexual lives such that an unwanted pregnancy is not a repercussion for which abortion is necessary. Is it the best solution going forward to provide unabridged access to abortion, or should there be other measures that we are taking to ensure that individuals have the tools that they need to make good decisions in their sexual lives and prevent unwanted pregnancies from even happening? What do you think, TJ?
Well, I don't think these are mutually exclusive ideas, in the sense that now that we live in a country where abortion is going to be banned in a meaningful number of states and whole swaths of the country, I think it's incumbent of us who believe in the right to abortion and believe that pregnant people should have the ability to exercise that right, even if their constitution is neutral on the subject, to make access available and to help create the infrastructure that allows people to exercise their rights, even if their own state would seek to oppress them. At the same time, we need to invest in all of the things that bear on somebody's reproductive health and life, from contraception, sex education, to addressing the maternal morbidity challenges that we have. All of those things require our intention and investment. And the dissenters in Dobbs, pointed this out very pointedly when they talked about Mississippi and what the consequence is going to be for removing the right to abortion for pregnant people in that state when they don't have any of those services and people are deprived of both information and resources to control their reproductive decision making.
Did you want to add anything, Whitney?
Sure. Yeah. I mean, I totally agree with all of that. And, I think, of course, we want everyone to have the resources and information that they need to be able to, build the families that they want, to become pregnant if they want to avoid pregnancy if they want to raise, families in safe environments, all of that. But I think it's undeniable that abortion is always going to need to be part of that conversation. There are a lot of barriers to healthcare access now, and we know that abortion bans disproportionately affect people who are already facing other systemic barriers, including systemic racism, to equitable healthcare access. And so, it's already a situation in which oftentimes the ability to, access the resources you need to prevent pregnancy, are not always within your own control. I think it's also important to remember that, a lot of states do not provide for comprehensive sex education. So this is quite literally something that a lot of young people don't have access to. And it's also really important to remember that not all pregnancies result from consensual encounters. So the basic idea that pregnancy is always something that with the right information and the right resources you're going to be able to prevent just isn't true. Contraception is also not foolproof. And I think that we should be able to, recognize that as well, that there are, pregnancies that happen even if you're on a highly effective, long-lasting contraception, and that there are situations in which people need abortions even if they intended to become pregnant and deeply wanted their pregnancies. There are many pregnancy complications for which termination is the standard of care. And there are many situations in which people's life circumstances change drastically and unexpectedly over the course of a pregnancy, such that even if they initially intended to carry to term, they no longer feel able to do so, whether that's for family reasons, economic circumstances, a sudden change in their family situation, needing to care for a sick loved one or a sick child, or changes in their own health or fetal diagnoses that change their ability to really feel like they can provide for an additional child. And so I think there's, yes, we want to make sure that people have access to comprehensive tools to control their reproduction and access to reproductive health care they need, but abortion is an essential part of that. And I think the notion that abortion is something different than that is just incorrect.
So I think we have time for one last question. And I will note that even though we're not fielding questions through this Zoom webinar, a number of NYU students have emailed me. So they are incredibly resourceful and have managed to break the Zoom barrier. So good for them. These NYU students want to know where the fight for reproductive rights is going next. So if you could give us a sense of what you're working on right now and where you are fighting. And they would also like to know what NYU law can do to be a part of the fight. Like, what should we be doing in our own community to make the prospect of reproductive rights more secure for those here? So if you don't mind telling us a little bit about what you're doing and what we could do to help, that would be terrific.
Sure, I can go first. So, lots of attention now is going to state court, and there's going to be a proliferation of legal fights in lots of jurisdictions. So stay tuned for all of that. But to the majority's point, things are also devolving to the states, and it's become a hot button legal topic, and it will continue to be. And there are a number of ballot measures that are very critical to be watching in this upcoming election. There will be federal legislative initiatives as well that the center is very much working on. A lot of work is happening behind the scenes in lawyers' offices. There are more legal counselors when it comes to the abortion right than ever before, as people try to accommodate this new reality and understand risks. And there are a number of task forces being led by the American Bar Association, by the New York Attorney General, by bar associations in California and elsewhere, to bring together private lawyers, to get them trained up to be able to provide meaningful advice to people who are really struggling. And then in terms of what people can do, there's plenty that people can do. I mean, for one, you can come join the front lines of the fight at a place like the ACLU or the Center for Reproductive Rights. We're hiring left and right because there's a tremendous need. But short of that, you have a tremendous amount of privilege and leverage in the spaces that you otherwise occupy. So wherever you go, be talking to your employers about the benefits that they provide to pregnant people who are seeking access to care. Many of you may go to law firms that have offices in states that will no longer recognize the right to abortion. And lawyers and law firms should be leading on these subjects. People who are interested in bar engagements and practice of law issues need to realize that the anti-abortion movement is not going anywhere, and they're coming for the lawyers next. You may have seen that Sidley Austin received a letter from Texas legislators saying that that law firm's decision to provide financial and practical assistance to employees seeking abortion care was tantamount to aiding and abetting Texas murder, and that the penalty will be new laws that require the disbarment of any attorneys that would be involved in providing that sort of support. That is an intrusion into the disciplinary procedures that guide our own practice, and all lawyers, I think, should be very offended by that and working to make sure that we are prepared when laws like that go into effect.
Whitney, I'm going to give you briefly the last word before I close up shop.
Thank you. And so I agree with everything that TJ just said. I want to lift up the point about the tremendous need for legal advice now. And so I think this is a moment when the entire legal community has something to contribute. I think one way that thinking about the Dobbs decision, and one important way to understand it, is that this is really a mass criminalization event. This is a situation in which, in a very short period of time, routine and essential medical care became criminal in approximately a dozen states, and more are expected to follow. And so I think the profound consequences of that and the severe criminal penalties, at issue, as TJ said, this is a place where there's a great need for legal advice, not only from those, working within large reproductive rights organizations like TJ and myself, but across, pro bono support from law firms, support from folks with criminal defense expertise. So I think there's a lot of ways that the legal community can contribute, and in ways that maybe and through spaces and employment that you wouldn't necessarily have thought of before. I want to also reiterate that at least for now, in the absence of a nationwide ban, state constitutions, state legislatures, state courts are incredibly important. So the ACLU is also, exploring state constitutional challenges, have brought a lot of new state constitutional challenges in the wake of Dobbs. And so I think I just want to reiterate how important it is to stay involved in state and local politics, to make sure that your elected representatives represent your values and, fight to preserve democracy. The opinion says take it to the ballot box. We need to make sure that people actually have access to the ballot box. So making sure that your representatives represent you not just on abortion, but on other things that make access to abortion, that access to abortion depends on, and that our other individual rights depend on. I also think that there's a lot of power in just using your voice. This is a time when I think there's no conversation too small about why this decision is important, about why abortion access and full reproductive freedom is important. I think especially in a state like New York that has state protections for abortion at the moment, it's critical that we not become complacent and that we don't stand idly by out of some false sense of security for ourselves, while others are facing the devastating harms that abortion bans and restrictions are causing. I do also want to just lift up again and plug the ballot initiatives that are ongoing. Next Tuesday in Kansas, there is a ballot initiative on the primary ballot there trying to roll back protections in Kansas for abortion rights. and to permit Kansas legislators to ban abortion. There is phone banking going on now through the campaign to defeat that amendment. So there are very concrete places that you can chip in now. If I'm able to drop a link into the chat to sign up for those phone banks, I'm happy to do so. But there are a lot of opportunities to get involved. Even at the local level, but also to provide support for the states that have now seen abortion access banned.
Let me give you an opportunity to drop that into the chat. I will just add a plug for NYU Law's Reproductive Justice Clinic, which is led by Sally Burns and Sarah Wheeler and is doing tremendous work, much of which supports all of the work that TJ and Whitney have talked about. This has been a really terrific panel. I've learned so much about this. Again, TJ and Whitney, thank you so much for giving so much of your time to NYU at a time when your talents are really needed. And we appreciate the time that you've taken today to help us work through these questions. And thank you to our audience for taking the time to join us today. We hope this has been informative and we're looking forward to more time with you in Zoom and in person in the future. So thank you.
Thanks so much. I wasn't able to drop it in the chat, but I don't know if Melissa, if you're able to, I just messaged it to you. I can't message everyone.
Okay, let me try. See, we're dealing with this in real time.
Sorry.
I don't think I can, but you know what? We will make sure this information gets to those who need to see it. So the Penelope and the team will get on this. So thank you so much for everyone for joining us, and we will see you soon. Stay safe out there.
Thanks, everyone.
Bye.